So I guess we'll call this meeting to order. So Darcy, could you do the roll call for us, please?
You're muted, Darcy.
I'm not hearing you. You're on mute, Darcy.
I always
There you
forget that.
go.
Commissioner Stevens,
Present.
Commissioner Murphy,
Present.
Commissioner Lee,
Present.
Commissioner King,
Present.
Commissioner Founds,
Here.
Commissioner Satter,
Present.
Commissioner Cantonwine,
Present.
and I have Commissioner Wilson who just popped up. I will move him over. So everyone is present and accounted for.
All righty. I'm going to defer kind of introductions with our newest member until after we do the public hearing, because we may have members in the audience. So in the interest of their time, we'll jump into the public meeting first, and then following that, we'll get a chance for all of us to introduce ourselves to our newest commissioner, if that's okay with everyone. But before we get into the public hearing, there is an opportunity for public comment. If there's anything someone from the public would like to share with the commission, other than what is on the agenda tonight, now would be the time for that. So do we have anyone in the audience that would like to speak? Doesn't look like it.
I don't see anyone.
Okay. So then I'm going to jump into the public hearing. So I have prepared a script. Most of you probably have it, so you bear with me as I read through this. So the public hearing is now open for the consideration of files ZO 437-25 and ZO 438-25. An application by M&S Investments LLC and Andrew Stamp of VP Law for a comprehensive plan map amendment to change the land use plan designation for the subject property from agricultural to rural industrial, with a corresponding zone change from exclusive farm use to rural industrial. No development is proposed with this application. Assisting us in the hearing today are several members of county staff, Administrative Specialist Darcy Reinhardt, Principal Planner Marcia Fritzy, and Planning Director Jennifer Hughes. This public hearing is being conducted virtually using the Zoom platform. Panelists for today's hearing, which include members of the Planning Commission and county staff, have both audio and video capability. The applicant will be added as a panelist during their presentation. If a panelist is participating with audio but not video, members of the audience will not see the panelist's name on their screens, but will be able to hear them when they speak. Audience members who have joined the meeting will have their mics muted unless they wish to testify, in which case they will be called upon to do so by the county staff moderator. Audience members' videos will not be turned on at any time. Today's hearing is being recorded as required by law. The county will post the recording on the county website as soon as possible. So I have a few general statements. The Planning Commission is charged with making a recommendation on the application to the Board of County Commissioners. The record from this hearing will be forwarded to the board, which will make the final decision. The board will conduct another hearing on this application on Tuesday, August 4th, 2026 at 11 a.m. That hearing will be de novo, meaning that the hearing will be started anew and additional testimony may be offered. Tonight's hearing will not go beyond 10 p.m. unless a majority of the Planning Commission in attendance vote to continue past that time. If not concluded, It will be continued to a date and time certain. The hearing may be continued for other reasons as well. If an announcement of an additional hearing date and time is made tonight, it will be the only notice given of that additional hearing. So here's how we're going to conduct the hearing. So first, we're going to get the planning and zoning staff report. Then there will be entry into the record of any additional correspondence that we received that may not be in our packet. Technical information from other government agencies, testimony, and then a planning commission discussion and action. I have a few more statements to make. The legal statements. This is a quasi-judicial land use hearing, which means two important things for those participating in this hearing. First, all of the criteria that staff believes the Planning Commission can use in reaching a recommendation are listed in the notice given for this public hearing and will be identified during the staff presentation. All testimony, arguments, and evidence must be directed toward these criteria or other criteria in the comprehensive plan, zoning development ordinance, or other land use regulations that the person identifying believes to apply to the decision. Accordingly, anyone testifying is asked to please direct your testimony to a relevant approval criterion. Second, failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties an opportunity to respond to that issue may preclude appeal to the Land Use Board of Appeals on that issue. Failure of the applicant to raise constitutional or other issues relating to proposed conditions or of approval with sufficient specificity to allow the county to respond to the issue precludes an action for damages in circuit court. Once final, the county's decision may be appealed to the Oregon Land Use Board of Appeals. At this time, I wish to ask members of the Planning Commission to disclose any ex parte contacts, bias, or conflicts of interest. Please indicate the nature and extent of the ex parte contract, bias, conflict of interest, and indicate whether you intend to participate in or abstain from the hearing. So, are there any commissioners that doesn't appear to be any? Nope. Okay. So with that, I'm going to turn it over to the planning staff to present the report. Martha, I presume you're up.
Yes, thank you. Good evening. I'm going to share my presentation. Let's see. Come on. All right. Does everybody see that as a slideshow and not with all my, okay. Excellent. So, hi, I am Martha Fritzy, Principal Planner for the county, and you might notice a different face on the screen here. That's Christian Snuffin. He's the county engineer. I asked him to attend today in case there were some specific traffic related questions for this one. So thank you, Christian. He is available for questions. And I'm going to get started. This is, as was mentioned, a proposed comprehensive plan map amendment and zone change. Specifically, the proposal would change the comprehensive plan amendment from agriculture to rural industrial with a corresponding zone change from EFU, exclusive farm use, to the rural industrial zone. This is being done under a specific statute identified for what is called abandoned or diminished mill sites. So a lot of you have been around long enough to know that typically when you try to change the zoning from an agricultural zone, it's extremely difficult. And it often requires what is called an exception to one of the statewide planning goals. Well, there are a few very specific exceptions to that requirement, and this abandoned and diminished mill site is one of them. So in this case, if all of the standards under ORS 1997.719 are met, no goal exception is needed in this case, which makes it a much easier process. Importantly, though, only the mill site portion of the property can be redesignated. You can't designate additional properties or even an entire property if it wasn't historically used as the mill site. Per usual, no development is proposed with this zone change, and this doesn't specifically authorize any new development on the site at all. That would have to occur after the zone change and would need to meet all of the conditions on this zone change, any other requirements in the rural industrial zone, including design review. So the site itself is on Kropf Road. It's a single tax lot. It's identified here. The whole tax lot is just under 21 acres. The portion that is proposed for rezoning is the portion in the southwest side that you can see is developed. That area is relatively flat and has been developed for quite some time as the mill site. The eastern and northeastern portions of the site do contain some steep slopes, protected areas, a pond, a stream. Those areas will not be a part of the rural industrial zone if this is approved. Those would remain in the EFU zoning district. The site itself is zoned EFU, like I mentioned, and it's in this large block of other properties also zoned EFU. It's in an agricultural area, roughly 4 miles southeast of Molalla, surrounded by farmland. It looks like, just from aerial photos, a lot of cultivated fields, some treed areas, although those are largely along, the water features, the creeks and streams. There are some dwellings in the area, typically associated with farms. There's not any rural residential zoning in the area, but there are some residences. So this is from the application. This is a zoomed in aerial of the area that is proposed for redesignation to rural industrial. It's that pinkish purplish line that is pretty narrowly drawn around the buildings. You can also see from the green contour lines that it is pretty much the flat developed area of the property. This area is currently developed with 13 buildings, some asphalt and other surface parking and storage. And so that's the area that's proposed. It is roughly 7.5 acres based on our calculation. And again, the remainder of that 21 acres would remain in the EFU zone. This is a photo dated somewhere in the 1950s from the application. You can see the mill as it probably originally was, based on evidence in the record, including land use applications that the county has. It appears that this mill was established originally in 1941. At that time, there was no zoning that would prohibit it. The first zoning was established on this property in 1976, and that was EFU zoning, although EFU in 1976 is a little different than EFU is now. Some things have changed, certainly. One thing that hasn't changed is that this mill would not have been allowed an EFU, and so it became a non-conforming use. And a non-conforming use essentially is something that was established legally at the time, but the zoning has changed, and therefore it's no longer allowed under zoning, but because it was established legally, it's allowed to continue. And as long as it continues, it is allowed to continue and or be altered. And in this case, there's a pretty detailed explanation both in the application and maybe not as detailed, but an explanation in the Planning Commission staff report of some of the verifications and changes that have happened over the years. Essentially between 1993 and 2013, the property owner at the time came in and asked for certain alterations to the non-conforming use. In some cases, it was adding some buildings. In other cases, it was allowing for some different types of uses on the property. Interestingly, you can see in this photo, let me go back. This property to the south here is developed, and it is developed sort of in association with this, but this was not part of the original mill. You can see that That's this vacant land up here. That development was allowed in about 2005, 2006 under an alteration of the non-conforming use. In other words, they were sort of expanding uses associated with this non-conforming use. So that's how that development got over on that other tax lot, but that is not part of the proposal today. That property and those buildings will remain in EFU. They will remain non-conforming uses. And so it confused me at first when I looked at all of this. I was trying to understand how those buildings got there and why they weren't part of this application, and that is why. Although there's been a lot of different sort of iterations of uses and expansions and alterations, currently there is not much going on this property. And based on the description of each building and what is in each building that was in the application, it's largely vacant. The buildings are largely vacant. There is Wilco has some warehousing going on here for their farm store supplies. A very small building is being used for pocket door fabrication, essentially assembling parts into, I guess, pocket door pieces. I'm not entirely sure. And then there's a business called Precision Drying, I think is the name of it. They are, according to the description, using some of the kilns that were on site originally with the mill. Excuse me, one of which has been replaced, and they're doing some redrying. The way it's described is that they are redrying lumber that has been processed somewhere else. I don't really know what the reason for that is, but I presume that there is some reason. But it is a slightly different use than was originally on the property. This is what's going on right now. This becomes important as we start thinking about an abandoned and diminished mill site. So procedurally, this is a quasi-judicial application. We are required to send notice. Notice was sent out to property owners within a half-mile of this site, and also any applicable agencies. On June 8th of this year, I have received 0 public comments on this application. The local community planning organization is inactive. The only comments I really have received are from Christian Snuffin, who's here today, the engineering staff. I always ask him to look at the traffic studies, and he noted that he concurred with the findings in the applicant's traffic study and recommended a couple of conditions of approval related to that, and we'll talk about that in a minute. So per usual, there's a lot of criteria that need to be met, including statewide planning goals, in this case, the particular ORS listed here, comprehensive plan goals and policies, zoning and development criteria. I'm going to not talk about every single one of these and touch on what I think are the most important. There are detailed findings in the Planning Commission staff report that you received a week ago. And I'm happy to answer questions if I don't actually talk about something that you had questions about in that report. We're first going to start with ORS 197719. So it says, paraphrasing, that a site that meets the statutory definition of an abandoned or diminished mill site may be rezoned to an industrial without an exception to statewide planning goal 3. However, if a county does that, they can only allow industrial uses on the site, not retail or commercial or even other uses that may be allowed in the industrial zone in the underlying zoning district. Those are not going to be allowed here, just industrial. And also, a county may not rezone to allow those non-industrial uses without following the usual rules, which may involve a goal exception. And also, I mentioned this, only the area of the mill site may be redesignated. So what is an abandoned or diminished mill site? It's complicated in some ways. So this is the definition right out of the statute. Our ZDO also mirrors this definition. It's a mill or plant or other facility engaged in the processing or manufacturing of wood products, including sawmills and facilities for the production of plywood, veneer, hardwood, panel products, pulp, and paper. that have to be outside of an urban growth boundary, were either closed after January 1, 1980, or operating at less than 25% capacity since January 1, 2003, and contains or contain permanent buildings used in the production. I put this whole definition up here because it becomes very important to understand if this property qualifies as an abandoned or diminished mill site, because we know there's stuff going on this property, right? And it has been going on. But what we need to figure out is that stuff going on actually, does it meet this definition of a mill site? So I'll start with sort of the low-hanging fruit, the A and C. They're pretty obvious. Yes, this is located outside of urban growth boundaries. It's, like I said, about 4.5 miles southwest of the city of Molalla. It's not in an urban growth boundary or a city. And C, does it contain or contain permanent buildings used in the production of manufacturing of wood products? That also is very clear from evidence in the record. It was a mill established in 1941. A lot of the buildings are still there. And there's a whole slew of aerial photos that were in the application that show various years. It's clear that there are buildings that were used for that purpose. So then we get to this issue of, well, was it closed after January 1, 1980, or has it been operating at less than 20% capacity since January 1, 2003? And importantly, we need to look at this specific list of things that are identified that under the definition that make it a mill site. It has to be whatever was there that was closed or is operating at 25% or less than 25% capacity, has to be something engaged in processing and manufacturing wood products, including sawmills, and that long list I'm not going to read again. The important part about this definition is that the state law narrows the definition by using this including. It is intended to narrow it not only to these items, but to items that are like this or similar in character. And so the use of the word including in statute, case law has found, does have the meaning not of making an exclusive list, but of making these are not my lawyerly words because I'm not a lawyer, making a narrowed down list of things that need to be similar in character. So as we look through the record and the evidence that was provided in the application, and we look at the old land use applications, we start to look at sort of these key dates. So January 1, 1980, we know that it was a mill. At one point in time, it was a lumber mill. It was very clear. Based on the evidence in the record, that was still operating in 1980. In fact, in 1993 is the first alteration of the non-conforming use that we have. And it discusses that even the sawmill was still operating at that time. But then when we get later to about 2000, there's some testimony that the applicant put in the record of people who worked in the mill and said that in 1999, when the original owner passed, they shut down the mill. There is an email also in the record that somebody notes in 2000 they're looking to buy the mill and that it was still in operation, although the sawmill was not in operation anymore. And so I think somewhere between before 1980 and post 1980, the sawmill stopped operating. But it appears, based on information also in further land use applications, even in 2006, there's a long list of things that were occurring on the property. And it was noted that the 13 buildings were still being used, that days and hours and use and number of employees fluctuate with the seasons, but it was still in operation. And then in 2013, there again is a comment about the 13 buildings currently being used for wood processing and lumber milling, although I'm not sure the sawmill was running, and that existing operations employed 30 people. And so there was definitely something going on that would likely fall under this sort of yellow highlighted manufacturing of wood products for some time. I don't know how much of it was going on post 2003. That evidence was not put in the record to identify whether or not it was diminished to 25% capacity. However, when we look at what is happening today, and bear in mind that it says was closed after January 1, 1980. It doesn't say when. It doesn't say within a year or 2 years. It can be closed presumably at any time. So we look at what's on the property right now. Clearly, the parts that are vacant or warehousing other types of materials do not meet this definition of a mill site. So then we have to think about the other uses, that are taking up the other buildings, the pocket door fabrication. Again, I think it really is just assembling pieces. They talk about having hardware that they're, bringing lumber in and attaching hardware to the lumber. That doesn't really seem to be of the same character as producing plywood, veneer, hardwood panel products, pulp and paper, which clearly begin sort of its primary processing. They begin with raw materials and turn them into something else. And so then it's just this other drying business, which are using the kilns that originally were part of the mill. And I think at some point it would have been easy. You would have to argue that, yes, that's part of the facility that's making all of these things. But at this point, that business appears to also just be taking in sort of third-party processed materials and doing something else with them. And so I think that it's pretty easy to find that what is happening on the property right now does not meet the definition of mill site, including sawmills and facilities for the production of that list of items. And therefore, it is considered abandoned for the purpose of this statute. Again, there's a distinction between things happening on the property, these non-conforming uses that have sort of changed in character over time, and the whole property being abandoned. The requirement isn't that the whole property be vacant and abandoned. The requirement is that this mill use is abandoned. And so in this case, both the applicant and staff have found that that is the case. And so that means we can move on. I promise this is the most I'm going to talk all night, because this is one of the most nuanced pieces. So once you determine that it does meet that definition, you do need to look at the other criteria and make sure that it does, or you can meet that. In this case, only the developed area of the mill site would be redesignated, which is that pink line that was pretty narrowly drawn around the existing development and buildings on this lot. Based on the old aerial photography and the land use approvals, this appears to be reasonable. This appears to definitely be the area of the mill site, the area that was originally, that did meet that definition of a sawmill and doing primary processing of the lumber materials, the wood materials, sorry. And then the other criteria require conditions to ensure that they're met, which we are listed in the staff report. There were a couple of conditions put on it. One of the conditions under state law is that only industrial uses can be allowed. And then the other one is that may not be rezoned except as provided sort of elsewhere in state law. Both of those would be conditions of approval. So, before I go on to that, the state law allows for this type of a zone change without consideration of certain administrative rules and other criteria under state law, but it doesn't exempt it from also having to meet local criteria. And so that's why we look at both our comprehensive plan and our zoning and development ordinance also. So I'm just going to touch on a few things in the local criteria, and some of you may have heard me phrase it this way before. I'm not going to go into all of the comprehensive plan policies. So I like to think about zone changes in terms of sort of the 4 big zone change criteria in the zoning and development ordinance and found in section 1202. The first being that the proposed zone change is consistent with the applicable goals and policies of the comprehensive plan. It kind of rolls up into the comp plan and to the statewide planning goals. And in this case, there wasn't anything really substantive in the comprehensive plan. There were policies in 5 different chapters that it needed to meet. Chapters 2 and 11 are largely procedural and coordination. That's on us for sending notice and doing the coordination activities that we do. Chapter 3 has a policy that's specific to rural wetlands and ponds, which essentially requires they be avoided. And in this case, that's pretty easy to make that finding because the rural industrial area is the area that is already developed. It is already outside of the wetland and ponds, and development would not be allowed to expand past that. Chapter 4 is also pretty easy. Sometimes it's hard to meet our criteria for applying a particular zone, but in this case, there is a specific allowance for rural industrial to be applied in this particular case for an abandoned diminished mill site. And then Chapter 5 requires a zone change comply with the transportation planning rule found in statewide planning goal 12. Again, there are some conditions required, but the applicant's traffic study found, and our county engineer concurs that with those conditions, the zone change can be found to comply with these things. The second criteria requires demonstration that any needed public services are available and sufficient for development that could occur under the new zoning designation. Again, in this case, this is pretty straightforward. There's no public water or sewer in this area and none required for this development. And county engineering is the surface water management agency in this area. And we do have a preliminary statement of feasibility signed by them that indicates that surface water can be addressed adequately on site. So that is met. And then the last 2 have to do with the transportation system, both that the transportation system is adequate and will remain adequate, which again ties to Chapter 5 and to the transportation planning rule, but also that the safety of the transportation is adequate to serve the level of development anticipated by the zone change. Again, a traffic study was submitted by the applicant. The traffic study found that the proposal would not have a significant effect on the adequacy or safety of the transportation system. And again, some conditions are required, specifically limiting the uses on the property. And because the traffic was modeled based on certain building square footage, there's a condition that would limit an increase, that would prohibit an increase in the building square footage. So it doesn't mean that the site couldn't be redeveloped. It just means that they are limited to the amount of square footage that is on the site. And we're going to talk about that really quick. So there are conditions number 4 and 5 in the Planning Commission staff report. The applicant called me up after the staff report was issued and had some questions about these 2 conditions. Well, the applicant's attorney, excuse me. And so he and I and Christian had a quick meeting phone call to discuss these. And hopefully I can explain this adequately. Like I said, Christian is here if I don't. The original condition under number 4, or the condition that you've seen, limits the uses to manufacturing or other industrial uses that generate less traffic, or less traffic generative. I don't have it in front of me, obviously. And this came directly from the traffic study because it was the manufacturing use that was modeled. But after having some conversation and discussing it, we came to the conclusion that it's not necessary to be this specific in this condition. And rather, because state law limits it only to industrial uses, that we determined that manufacturing really is the most traffic generative use in the list of industrial uses. It's not necessary to limit it to essentially require anyone coming in to put a different use besides manufacturing have to show something about the traffic generation, knowing that it's going to generate less traffic than the manufacturing use. And so we think we've all agreed that it is sufficient simply to limit it to the industrial uses allowed in the rural industrial zone, that it's not necessary to sort of create this extra step for other industrial uses that would be allowed that are not manufacturing. hopefully that makes sense. So we are recommending actually amending that condition, and I have some language in the next slide to simply limit the uses to the rural industrial like state law requires us. The next one, condition number 5 is about limiting the building square footage. And so I noticed as I was writing this condition that the traffic study modeled 87,100 square feet based on the application materials and the diagram that I showed you earlier with all the buildings and the square footage. I put them in a spreadsheet, I added them up, and it added up to 92,750 square feet. And so we talked to the applicant about that, and excuse me, the applicant's attorney, and he had indicated that he's going to verify the total square footage on site. The intent of the modeling and the intent of this condition was to not make them remove square footage, but to limit the building square footage to what exists currently. And so we need to reconcile those numbers, and we are working with the applicant's attorney to do that. It hasn't happened by today, and it probably won't. We're going to have to do that before the board hearing. I think based on that conversation, the county traffic engineer wasn't particularly concerned if it ends up being 92,750 square feet, doesn't think that there's going to be a concern for traffic, although we are going to require an addendum to their traffic study just so we know what those numbers are and they can demonstrate that. It's possible that this particular condition will change, but I want to assure you that the intent will remain the same, that we're just trying to figure out to reconcile how much square footage actually is on site and make sure that's modeled, that meets the criteria, and that's what it would be conditioned on. So, in conclusion, staff did find that the application meets all the applicable criteria for the comprehensive plan map amendment and zone change, and recommends approval of the files with conditions as noted in the staff report, except as with the revision to condition 4, which simplifies the limitation and would limit it just to industrial uses that are authorized in the rural industrial district. And I threw accessory uses in there too, just to be clear that we would allow that. Jennifer Hughes may not think that's necessary, and she can tell me if I need to strike that. But the intent is to make this a little more straightforward and not have to cause everybody coming in to look in the ITE manual and tell us that their industrial use generates less traffic than manufacturing when we've already determined that manufacturing was the most traffic generative industrial use. That's it. Any questions? Oh, can I stop? Am I still sharing?
If you have any questions, can you raise your hand, please?
Stop sharing. There we go.
Commissioner Wilson, you're on mute.
Just for my understanding, what's the difference between rural, industrial, and manufacturing?
So oh, hello? Oh.
Yeah.
Rural industrial is the plan designation and the zoning designation that would be applied to this property. The rural industrial zone allows a number of different types of uses. Manufacturing is one of those uses. Manufacturing of certain materials is one of those uses that is allowed.
So give me an example of something that would be a rural industrial and would not apply to manufacturing.
A use in rural industrial that is not a manufacturing use?
Yes.
Well, give me 2 seconds to open up my zoning ordinance. Because I could guess, but I want to make sure that I'm right.
I mean, somebody must have defined what rural industrial was and limited it to that as
Okay.
to somebody manufacturing a car or putting together a tractor or something like that.
So rural industrial allows a number of uses that are not, that are commercial in nature. It also allows things like fraternal lodges as a conditional use, dwellings as an accessory use, farmers markets. It allows plant nurseries. It allows certain recreational sports facilities, but none of those are industrial uses. Those would not be allowed on this particular property. But it would allow so it allows manufacturing, fairly generally manufacturing uses.
So let's say somebody wanted to build a piece of product that would harvest corn or something like that. Would that be an industrial use?
I'm sorry, I'm having a really hard time hearing, Michael. Is everybody else, or is it just me?
But I'm a little, trying to figure out what manufacturing difference is between rural industrial production.
Well, so manufacturing is a type of rural industrial use, or it's a type of industrial use. The distinction is that rural industrial is the zoning district, as opposed to an urban industrial that allows a whole lot more things. Rural industrial is intended to allow industrial uses that are compatible with the rural area.
Kind of vague. Okay, I got it.
Uh-huh.
Commissioner Stevens, I think you're next.
Thank you, Chair Peterson. Real quick, you mentioned, Martha, that, wow, is everybody getting feedback?
Yep.
Okay, so it's not just me. Okay, I'll talk slowly. You mentioned that the CPO was inactive, which I think is Malala, and reactivated a bit ago. But you did not receive any CPO input?
It's in the South Canby CPO area.
Oh, okay.
And they are still inactive.
South Canby is inactive. Okay, that was number one. And I guess out of curiosity, and along the same vein as Michael Wilson, has a use been shared, like a future plan or use of the site?
No, not that I'm aware of. The applicant may be able to address that. I think there's at least one representing the applicant here.
You're on mute, Murph.
Thank you, Tom. Hi, Martha. Great package. I love having things to do. A lot of digging there. Number one, this is going to change zoning. It's also going to, it's tax based also, isn't it? Does somebody have a mic on that?
I don't know. I'm really getting a lot of feedback and having a hard time hearing.
I think it's coming off Commissioner Wilson's mic.
Oh, he just muted.
Okay.
Okay.
Is this any better?
That's much better. Can you ask the question again, please?
Yes. So since we're going from EFU farmland, which has basically a low tax designation, low rate, this is going to increase its taxes, isn't it? And will there be a backlog that it has to pay for this changeover?
I don't know. I'm not the tax assessor, and that's not one of the criteria for the zone change. I can say that just because it's zoned agricultural doesn't necessarily mean it has a low tax base, because I would be surprised if this property was in farm tax deferral. It's been a mill for quite some time. But again, maybe the applicant could verify that or answer that for you.
Right. I just thought I'd ask. One of the things that came through. Another is since it has an on-site wastewater treatment, have the drain fields been located? I see asphalt and buildings only on the area that's changing. So is it going to go to a different lot for its wastewater treatment?
Not to my knowledge. That is also something maybe the applicant can verify.
And this would probably go through, have to be discovered when building permits or prior to building permits, I would imagine.
Well, no, I mean, quite frankly, we need to make sure that the zoning line is drawn in the right place, that it's within this, within the rural industrial zone. So we
Well,
would certainly verify that.
That leads to the next question.
Mhm.
The stream is considered a type F stream. Fish are in this stream. So is there going to be an increase in setback from its water line, high water line?
An increase in setback?
Yes.
Well, no, we're not going to make people move buildings. And so typically if you have a non-conforming setback from a stream, you are allowed to maintain that setback if you were to remodel or replace your buildings.
Even with the zone change.
Yes. The zone change doesn't change that. We would be potentially fixing some of the non-conforming use issues, but if there are existing buildings that were established legally, we may not be fixing all of the non-conforming building location or, issues like that. There still might be non-conforming uses on this property in terms of setbacks.
An observation that I came across in the comprehensive plan, page 3, chapter 3, probably second paragraph, describes the loss of ag land in Clackamas County in the last 30 years as being over 100,000 acres. I'd like my commissioners to know that's straight out of the comprehensive plan. Not that it should affect this, but we do have a loss of ag land, ag forest land. That's a pretty high number. So thank you, Martha.
Okay, Commissioner Lee.
Yes, thank you, Chair. I have some environmental questions for you, Martha. I understand from the packet that there's a groundwater sensitive designation on the site, and that there's also, similar to Murphy's question, that there's Sensitive Creek right next door to the site, and that the applicant provided a hydrologic study of the wells, and they analyzed how that hydrologically it's all interacted with one another and the other wells in the area, but yet there was no water quality analysis done on or testing of the water coming out of the well.
So that's fair. It is in a groundwater limited area. You're correct. The zone change criteria for properties in a groundwater limited area are minimal, at best. The thing is, section 1000, oh, help me out, Jennifer, 1002, is it? That require, or is it 1000? No, it's 1002. Certain development, including industrial development, or if you were to do a subdivision, which couldn't, well, I guess an industrial subdivision could happen in this case. It does require the hydrogeologic report. And so I did look at it. There was no basis to require any sort of quality testing of the water for the zone change, because it's not a particular criteria, but any development that happens in any industrial development that happens in the rural industrial zone, if it is approved, would be required to meet all of the standards in 1002 for the hydrogeologic report, the analysis.
Okay. So we have no water quality testing done, and we have a sensitive creek next door, and we know it was a mill site, and we know there was a massive fire, and we know all the activities that have been going on the site. Has anybody done an environmental phase 1 report on the site?
Not that I'm aware of. I didn't find any in the non-conforming use verifications and alterations. And again, it's not a requirement for the zone change. This development already exists. But these things would need to be considered moving forward with any sort of redevelopment on the site.
Exactly. And I'm not sure how we can meet goal 5 of the statewide planning goals in chapter 3 of the comp plan that protects natural resources without some sort of environmental assessment of the site. That's just my 2 cents. Thank you.
Thanks.
Commissioner King, your turn.
Thank you. I'm the new guy here. I had a process question. In terms of, since there's been no public testimony or response, the notice went out to neighbors within half a mile. This is a pretty rural spot. I'm wondering, is there like 3 neighbors or 4 neighbors? I wonder how many notices went out for this change.
I need a minute to look that up, and I'm happy to do that, but we can, if you can give me a minute, we can move on to the next question.
Yeah, I'm just curious because
Oh,
no response. That's one thing that's kind of jumped off the page to me was that there's no public response. This is a pretty big change, and so I was just curious, like, maybe it's not on everyone's radar. The other thing was, have we gone through used this statute in Clackamas County before for another? I mean, it's been around for 20 something years. Have we gone through this with another mill site that has used this statute to change?
so not that I'm aware of. There was one that was talking about using it and was able to do a zone change through a different process. I don't think it is used a whole lot across the state. I talked with the DLCD representative, Department of Land Conservation and Development, and she had mentioned that there was a lot of new people in the department, and a number of people had come up to her and said, I didn't even know this existed. So
Well-
it's not commonly used, but I'm sure it has across the state at some point in time.
Okay. Well, that's why we pay lawyers to find this stuff. So the change to your proposed change to condition 4 is now allowing all the rural industrial use. So is that really even a condition anymore at that point? Like it seems like we're just saying it seems like it's not a condition if we're saying that all the uses are in this RI zoning is allowed, where before we were saying they needed to demonstrate some certain traffic thing. Is it even a condition anymore?
So yes, and I apologize if I wasn't really clear. The condition is that only the industrial uses that are allowed in that zone would be allowed. There are other uses allowed in that zone, like recreation facilities that are not considered industrial uses that would not be allowed on this site, but could be allowed on other rural industrial sites.
Okay, thanks for that clarification. Yeah, and I think this was finally just for my information, is in this zoning, is any future development going to have to go through design review, or is there things that could happen as of right that wouldn't go through? Like any future change in terms of the physical structures on the site are going to have to go through design review. Am I understanding that correctly?
Yes, that's correct.
Okay. All right, I think that's it for me.
So it looks like we sent out, I mean, it is a rural area. There's not a lot of neighbors within a half mile, but it looks like there were 27 minus 2, about 25 neighbors within a half mile, in addition to agencies like the fire district and other and the state agencies that were notified.
Okay, great. Thanks.
Commissioner Wilson, you have another question?
I want to give Martha a break here and address my question down to Christian. How you doing, Christian?
Doing well. How are you?
Fine. Haven't seen you in a while. I see from the square footage on the traffic study, I have a question about that. I understand there's about 30 employees there now presently on site for those various things that they're doing there. Do you have any information on the current traffic volume for that site?
Yes, the traffic study did assess what the current trip generation was. And let me get to that. For the PM peak hour, it was 5 trips total.
Okay. Now, why does the square footage have an impact on a traffic study? I mean, the place could be using for storage stuff, and it doesn't only have 2 or 3 people there, and very limited volume. So why does the square footage have an impact on the limiting of the traffic study? You're saying, we're saying we're going to limit the square footage based upon the traffic study.
Right. In ITE trip generation, the number of trips is often, well, it's associated with one variable or another. And in this case, for these uses, the variable was square footage of the buildings. So there's a general correlation between the size of the building and the number of trips generated. There are other variables such as, I'm sorry, go ahead.
No consideration of what is being used there, what the facility is being used for. It's only the square footage.
The square footage of a manufacturing land use.
But this is a rural industrial, not a manufacturing.
Well, manufacturing was determined to be the most intensive trip generating use of the uses that would be allowed.
Okay. Thanks, Christian. Look forward to seeing you.
Yeah.
Martha, just a quick question. How does Clackamas County zone for pellet manufacturing? Is that under wood manufacturing or wood processing? What they used to produce at this mill site, I was digging through the state and it's more or less under a fuel regulation that I could see. Now, are we treating this as a fuel regulation or a wood processing if we were to deal with this as a pellet production, pellet manufacturing?
Well, that is an interesting question. We, based on the alterations of the non-conforming use, we're looking at it as wood processing. As I was digging into sort of the definitions of things that are like plywood and veneer and that list, and looking at the different like NASICS categories of the manufacturing, it became clear to me that wood pellet manufacturing really is sort of biofuel manufacturing. And I don't think we historically have looked at it that way. It is no longer on the site, so I also feel like this is a really big cop-out, but we don't actually have to define that right now. But I think that maybe how we've looked at it has changed over time.
Yeah, digging around, it's not an easy find with the state either, as I was digging around through their regulations on it. Definitely needs work. Thank you for answering that.
So are there any other questions of staff before we move on to the testimony?
One more quick question.
Yeah.
So, if this rezoning did not go through, is every new use on the site right now, this new non-conforming use have to go through a process like, does the rezoning in terms of just continuing on as it is today just create less friction for the owner of the property going forward? And if so, like, why aren't they including if they're putting together 625 pages of information to rezone this, why is it not including the additional buildings in the site to the south? I guess I have some cognitive dissonance on why that's not included if they're going through this process, and where the friction is for them, and what happens if this doesn't go through for the future of the site.
That's fair. I see Jennifer smiling. I will try to answer this quickly, Jennifer. Because that's a very important and big question. So why they're not doing the other site is a little bit easier for me to answer. The reason they're not doing the other site is I don't think that they thought they could demonstrate that that portion of the development was part of this mill site. And if you recall, ORS 197 requires that the rezoning only be of the mill site. And so because that was done after, my guess is they didn't think that they could argue that. So, and again, they could verify that, but the other part of the question about non-conforming uses is unfortunately a little complicated. So yes, any alteration of a building or a different use that is put on this property requires an alteration of the non-conforming use, a land use application and approval, and essentially to demonstrate that it won't cause any greater adverse impact than the non-conforming use does right now. As a part of that, you also need to demonstrate that the non-conforming use or uses on the property have not been discontinued for more than 2 years, and I think they may be at risk of that at this point. We did not make any official determination about which of these uses are still legally non-conforming uses on the property. If this were not rezoned, every time something changed on the property owners need to go through an alteration of that non-conforming use. And I think that that is what they're trying to remedy here. That was my short answer.
Okay, well, it sounds like some of the questions may be questions for the applicant as well. They appear to me they overlapped a little bit. So if there are any other questions of staff, I think we'll move on to the next part of the process. So have we received any correspondence on this matter other than those items included in our meeting packets?
No, we've not.
Okay. And are there any other government agencies here to provide technical information related to the application? I don't believe there are. I can't see the list, so I don't know.
I'm going to say no to that also.
Huh?
I'm going to say no.
Okay. All right. So now we're going to move into the testimony section of the hearing. And so this is how this is going to work. First, we're going to hear testimony by the applicant or their representative, and we'll give them 15 minutes, but if they need a little more, I'll be flexible. Then there'd be testimonies from representatives of recognized community planning organizations or hamlets, maximum 5 minutes per CPO or hamlet. Then any other testimony, and I believe someone in the audience had raised their hand, that would be their opportunity for them to raise their hand or ask questions. And that would be 3 minutes per speaker. There will be an opportunity for the applicant's rebuttal, which is limited to arguments addressing evidence already in the record. And that's 10 minutes. And then there will be an opportunity for planning and zoning staff's rebuttal, which is limited to addressing any evidence already on the record. So if you want to provide testimony, you will use the raise hand feature in Zoom. Please do not raise your hand until reach the point of testimony order where you are eligible to testify. Attendees on a PC or iPad, you have a raise hand button on the Zoom bar. It's top or bottom, depending on your device. Attendees by phone use the *9 to activate the raise hand feature. When the moderator switches you over to provide testimony, your access will look different for a moment. Primarily, you will see all participants' cameras, not just the one who is speaking. Staff will call upon you when it is time for you to provide testimony. Once you have provided your testimony, your mic will be muted and your screen will be returned to normal. So with that, the applicant now has an opportunity to present their proposal. So
I have Allison Duna.
Hi, can you guys hear me?
Yes.
My audio working? Hi, my name is Andrew Stamp. I'm using a different person's computer. I might show up as Allison, but hopefully you can tell that I'm not Allison. But anyway, my name is Andrew Stamp. I'm a lawyer at VF Law. I co-wrote the application along with my associate Spencer Petrowski, who he probably did 90% of it. But just to reminisce, the first time I appeared in front of the Clackamas County Planning Commission, I think was 1998. So I don't know if any of you were on the Planning Commission in 1998. I kind of doubt it, but that was the first time for me. But I'm glad to be appearing before the Planning Commission tonight. I do want to say I'm not going to give a long presentation because Martha did such an excellent job, and she really did a great job fielding a lot of the questions too. So I don't think I would have said anything different than Martha said. So excellent work on her part. One observation I'd make about Oregon land use is rural industrial zone is a little bit of a, I want to say, well, I'm not going to use the word I'm thinking of, but it's a use that is under appreciated. And because the only uses that were zoned rural industrial when Senate Bill 100 was passed and, you know, counties were going ahead and adopting comp plans, the only rural industrial areas were uses that where they already had a use there on the site. You know, the only sites that were zoned rural industrial were areas that already had a rural industrial use. They didn't take 100 acres of vacant land and say, this will be our rural industrial area. And so there were certain, you know, that's one of those uses that is very hard to, the only sites that are currently rural industrial are sites that usually have stuff going on, and they don't turn over very often. The people that have them use them, and it's very hard to get that kind of land. The Oregon statewide planning goals and the program in general really tries to push industrial users into urban industrial zones, regardless of whether they need the urban services that are associated with those urban industrial zones. So there's lots of rural industrial users that they're caught between a rock and a hard place because they can't afford the $250,000 an acre that it costs to go into the Estacada, you know, urban industrial area, or the city of Sandy's urban industrial area. They can't really afford that. And but it's hard to find these rural industrial areas. So, you know, we've been talking to the legislature about this for many years. And in 2003, one of the ideas was, well, we've got all these abandoned mill sites, you know, because Oregon doesn't really do logging anymore at the same intensity that it did in the 60s, 70s, and 80s. And these are underutilized sites, and these are sites that are really no good. They're oftentimes zoned EFU or zoned for forestry, but they're really not good for resource use. Why don't we pass a bill that allows these sites to be redeveloped? And so House Bill 2691, 2003 was the result of that effort. And I remember, you know, being involved in that when it was going on. ironically, it hasn't been used very much. This goes to some of your commissioners' questions. How often does this get used? I'm only aware of a handful of cases where it has been used throughout the state. And, one of the things that attorneys like to do when we get when we have a potential land use application that we have to write is we go, well, let's find out, let's get 5 different applications that other people have written and kind of cut and paste out of those. That's the classic, why reinvent the wheel if someone already did it successfully? Not to mention you can read those applications and kind of see what problems they ran into and how they dealt with them and stuff. So it's always good to read those old applications. But what I found was there wasn't a whole lot out there. So we kind of ended up having to go from scratch. And that's one of the reasons this application took so long to generate. The other problem we ran into is that various uses on the site, were at some points it sounded like they were going to stay, and then some of the uses decided to close down. Like, for example, the Traeger pellet mill, one of the reasons we didn't include them is because for a while they were telling us that they were going to stay. And we figured, the application was complicated enough as it is, and involving the Traeger site, which has its own unique set of circumstances, as Martha indicated, made the application more complicated. So we decided to just dumb it down as best we could and give you the cleanest, easiest application to approve. We probably will come in at a later date with another application for the Traeger site. It more than likely will be a goal exception of some kind, but that's a little bit to determine. And I was talking with Martha a few days ago and said, I've got a couple different ideas about how to do this, and I'd like to talk to you about which application you'd rather see, what would staff be more likely to approve. So I'm hoping to have that conversation at some point. But for here tonight, we don't need to worry about the Traeger site. The question was asked, well, if you're not doing manufacturing rural industrial sites, what other uses could you do? One of the classic examples, and this has been a huge problem in Clackamas County, is contractor establishments. And what happens is you'll get a guy who'll start out as a small business and he'll do it as a home occupation. I'm sure you've had many of those cases. And as long as they've got 3 or 4 employees and a few vehicles, that works out great. But eventually, the ones that actually know what they're doing grow. And next thing you know, they've got 25 vehicles and 30 employees or something like that. And their neighbors start complaining about this home occupation that just sort of outgrew itself. And so code violations get filed. They come to me and say, what should we do? And we say, you got to move your business to a rural industrial area or an urban industrial area. And they say, we can't afford urban industrial. I said, well, then it's rural industrial. Well, there's no land available for this. Okay, well, then you're just move to Idaho then, and because they got plenty of land and they don't care what you do. And so, those are the tough conversations that we have with our clients. And oftentimes the answer is move to Idaho. And I've always thought, even though that's good legal advice, it's kind of crappy for Oregon. And as an Oregonian, I hate giving that advice. I hate giving the advice, move to Idaho, but we do it very often. And so this, to me, is a step in the right direction for kind of fixing that move to Idaho problem. And because those are some of the uses that could be allowed. Vehicle repair businesses is another example. The guys that are too big to do home ocs. So anyway, those are some examples of some of the clients that we might be able to attract. Some of our buildings are pretty big, and those might be good for warehousing and things. They're all solid buildings. They're all well built. The property is not in farm tax deferral, by the way, because they're not farming anything. So it's kind of one of the requirements of being in farm deferral is you have to be in farm deferral. You have to have some actual farming going on, and we don't. So anyway, I think those are some of the things that some background that I wanted to give you. Martha was correct. We somehow, when we originally did the application, we had our traffic engineer, we told him 87,100 square feet of building size. And I think later we figured out it was closer to 93,000. So we're going to have to fix that little error. It's a little discrepancy, but we may as well fix it. We'll do that, as we move forward with the project. Someone asked about environmental phase ones. That was done at the time of purchase in 2015. Obviously, nobody in their right mind buys old properties that have been used in the 30s, 40s, 50s, 60s without doing some kind of phase one and oftentimes a phase two, because you don't want to buy a property that ends up being a contaminated surplus site. So that was done, and this property is remarkably clean. So that's good. Someone asked about goal 5. In a PAPA context, post-acknowledgement plan amendment context, goal 5 really only applies if there's a goal 5 resource on the property that's being rezoned. And in this case, there's not. And that's why goal 5, it's pretty easy to meet the goal 5 criteria here. And as Martha pointed out, right now we've got a whole lot of non-conforming uses on the property. One of the big reasons we want to rezone to rural industrial is so that we're kind of shovel ready for the next guy that wants to come in. We don't want to have to say, well, maybe you could get it, maybe you won't, but you got to go down and talk to planning and they'll run you through a type 2 or a type 3 and it'll take 6 months. And maybe if you're lucky, you get it, maybe you don't, and people are like, wow, I can't be unemployed for 6 months. That's a problem. And so, being able to be shovel ready and just move right in as an allowed use in the zone is a very, very attractive thing for a property owner. So anyway, unless there's more questions, I think that those kind of summarize the things that I heard and wanted to address. But I know you probably have some more questions, so I'm open to taking those.
Okay, thank you for the presentation. It looks like Commissioner Wilson has their hand raised. You have a question?
Yeah, thanks, Tom. Allison, you're representing an investment corporation, so the corporation you're representing is really not going to be using this property. They're probably going to be looking to sell it, from what I'm hearing from you. And so they're looking at this change in the zoning to aid in their marketing of this property. Is that correct?
The audio. Okay. I got it. Commissioner Wilson, M&S Investments is really two people. It's Mitch Magenheimer and his wife, was it Sarah? Yeah. And so they're not some big nameless, faceless corporation out of New York City or Delaware or something. They're really just local people that live right down the street from this area. And these are folks that grew up, lived their whole life in the area. What they want to do is lease the space out and get rents out of it. So, that's what they're doing now. They've got tenants in there and they're hoping to get more tenants once it's zoned rural industrial. But, it's a long-term hold for them. They did buy it and they're making payments on it and that kind of thing. So the way it's working right now is I think the rents pay for the, whoever it is they bought it from, that kind of thing. But eventually, when they own it free and clear, it'll be a good investment, but it's really important that we have people like that that'll do these things, because most people can't afford to buy a big property like that. And you know, so to have someone that's a local person, in fact, that steps up to the plate, buys it, and then offers that up for rents at, you know, to other people in the community, that to me is a real good community service. I mean, they make money off it, obviously, but you know, these are people that might otherwise have to go to Sandy or Aurora or Woodburn and pay even more money for industrial land, you know, urban industrial land, which most of them can't afford.
Okay.
Does that answer your question, sir?
I'm not really concerned about, you know, the corporation piece, and I'm glad to understand that it's some local folks. Now, is that square footage limitation going to impact their purchase of this property? I personally don't think that square footage is a reasonable thing to do, you know, reducing it down like that. But I'm just questioning you: is that going to be a big burden on them?
Well, the reason you have the square footage limitation is to deal with the transportation planning rule. And, you know, one of the things the transportation planning rule says is that if you change the level of service of an intersection, you know, 2 miles away, then you've got to pay to fix that intersection. And so we don't want to fix intersections. Obviously, we don't have that kind of money. And so, you know, what we did, we told our traffic engineer, hey, we want to have as many trips as we can have without blowing out any intersection or, you know, causing the level of service to fail or to go below standards. And that's what our traffic engineer came up with. So I think, you know, we want as many trips as we can have, but by the same token, we don't want to fix intersections. So that's the compromise. And, you know, and that's a reasonable compromise. Now, if in the future, let's say Elon Musk decides that he wants to put some rural industrial use there and he doesn't care what it's going to cost, but he's got a lot of trip generation, then we'll say, all right, Elon, then how about you fix that intersection? We'll put in the new land use application to Clackamas County, and they'll tell us to fix the intersection, and we'll send you a bill because you've got more money than you know what to do with, and everyone will be happy. You know, that could happen. It's doubtful, but you know, stranger things have happened, I guess. So, you know, that's the line we're trying to draw, is that we want as many trips as we can get, but we don't want to get Christian snuffing mad at us that we're messing up his intersections. Does that make sense?
Yes, it does. Now, I understand there's like 30 people that are currently employed there. You don't know who might want this property, but I have some concerns about, you know, those folks losing their jobs and all that, and that's not a big problem for you, but it's something to consider. I'm assuming that they're going to own the property for a little bit at least until they can find somebody to lease it to, or you're going to, you know, if you buy it, you're going to have it leased to whoever's there now, I think, right?
Yes, we're going to continue to lease to any tenant who wants to stay. But, you know, speaking for my applicant, I'm sure he would love to have more tenants. Yeah, and I think we'll get more tenants once it's rezoned rural industrial, because there's probably a lot of people that are a little bit scared off by the non-conforming use aspects of it right now. It's hard to talk to a potential tenant and say, well, we don't really know if we're going to get approval for your use as an alteration of a non-conforming use. I mean, maybe we get it, maybe we don't. We'll let you know in 6 months or 8 months, because it usually takes us a couple months to draft an application, and then it takes 5 or 6 months to run it through. So, those are the kinds of problems that we want to avoid by rezoning it. It'll be shovel ready, so to speak. We're not actually, and I say shovel ready, we're not actually planning on building anything new, but tenants could move in, start their business, a day later or a week later, really fast turnaround.
So whoever you lease it to will have to be rural industrial type production, right?
Yes, manufacturing or, like I said, contractor establishment, vehicle repair are kind of the obvious industrial users of that. It won't be commercial. There won't be any clients. It won't be a commercial nursery where people are coming to look at pots and plants. It'll be mostly manufacturing, I think. That's the obvious thing there.
Okay. Thank you for your response.
You're welcome, sir.
Commissioner Cantline, you have a question?
Yeah, thank you, Mr. Chair. I just wanted, Mr. Stamp made a comment that I just wanted to emphasize as important, that these are local owners who are doing something constructive with the property, and from how it appears in this application are simply looking to make the property more marketable and more commercially aligned with a productive use. And I think to the extent as a planning commission, we can support that within the bounds of the law and the relevant rules. To me, that should be a kind of part and parcel of what we do. So I just want to go on record and share that sentiment. Thank you.
Excuse me, you don't have a question for the applicant. You're just making a general statement?
Correct.
Oh, okay. Yeah, and that's fine, but usually we wait till deliberations for those, so. Okay, so no other questions for the applicant from you? Okay, I guess I'll move on to Commissioner Lee.
Yes, thank you. Mr. Stamp, I'm glad to hear that a phase 1 environmental was done on the property. Would your client be willing to enter that phase 1 report into the public record in an effort of transparency?
We lose him?
My guess is they're talking amongst each other.
I'm sorry.
Oh.
I'm sorry. I muted myself and I forgot to put myself back on. I think they will. They're not here tonight. It just so happened that the hearing date tonight came at an unfortunate time for them. They had a pre-planned vacation. I think this thing had been on the books for a year for them. So they're out of the town and not in a place where they have coverage. So I wish he was here tonight to answer your question definitively, but I don't see why they wouldn't. It's rather obvious you don't buy $1 million properties without doing a phase 1. You'd have to be. I don't know anyone that would do that.
Totally
you'd
agree.
have to be pretty. Yeah. So I'm sure it's no problem. I hate to put words in his mouth, but I can't imagine it would be a problem.
Yeah, all you can do is ask, and I appreciate that.
Yes, sir.
Are there any other questions for the applicant? I don't see any other hands raised. Okay. So I guess we'll move to the next round, and there'll be another opportunity perhaps for the applicant to respond to some other things that come up. So we're not cutting you off just yet. So are there any representatives of community planning organization or hamlets here to speak? I'm assuming no. Okay. Now we'll have an opportunity for public testimony. So again, as I mentioned, please raise your hand using the Zoom if you want to testify. And for the record, please begin by stating your name, where you are from, or who you are representing. And if you would like a copy of the final Board of County Commissioners decision on this matter, please provide your mailing address so we can send that to you. So if there's anyone who wants to testify, you each have 3 minutes to testify. Darcy, do we have anyone in the audience that wants to testify? No? Okay. So we don't have any in favor, or we don't have any opposition. We don't have any neutrals. We just, okay. So we're done. Okay. So one more chance for the applicant, if there's anything that they would like to say before we move on. Now would be an opportunity. Anything that's come up that you would like to rebut, or any closing statements? Now would be the time.
Thank you, Chair. Obviously, I didn't expect anyone to show up. Mitch and his wife have lived in the area a long time. They know everyone in the neighborhood. They have very good relations with everyone. They're the type of people that, you know, if you need a tractor, they're there at your house with a tractor to help you do what you need to do, you know. So we did not expect there to be any opponents to this application. So, you know, if we thought maybe if, you know, if Thousand Friends or some of the advocacy groups didn't like it for whatever reason, they might show up. But we even talked to them about it, and they seemed to be fine with it. They said, as long as you're not converting usable farmland to rural industrial, we're okay. And we said, nope, the only thing we're really proposing is, you know, where's areas where there's concrete. And so that was kind of the end of their beginning and end of their concerns. So, so it is comforting to hear that there aren't any opponents here today. I think that's a testament to Mitch's character.
Okay, great. Thank you very much for your comments, and we will take that into consideration, all those into consideration when we get into deliberations. So I'm now going to close the public testimony portion of the hearing. And now it is open for discussions or comments from the commissioners. And it appears that Commissioner Kentwine already went on record where they're at. Their position is. Who else would like to comment at this point? Commissioner Murphy, I see your hand up.
Thank you, Tom. This is a question for Brian. Brian, would you know if they could access or could we access the DEQ or the environmental phase 1 report? Should they be filed with DEQ?
Possibly, if it was actually filed with the DEQ, but if it was performed as part of a land use action, probably not.
Probably not. Okay. Thanks.
Mm-hmm.
Commissioner King, you're next.
Thank you, Chair. So after going through all 625 pages of this, it seems to meet the criteria, and the current zoning from my chair appears to it's not taking any agricultural or farmland out of the county, because it hasn't been since 1941. So it's not it's just sort of bringing it in line with what's been going on there for however many years. All the current zoning, all it seems to be doing is creating friction for the owner, and so I think I'm kind of on the same page as Commissioner Kentwine that this seems to make a lot of sense to me. And the fact that Thousand Friends has not come out against this, I mean, if anyone was going to, it would be and have a concern on that side of things, they would have voiced them, I'm sure. And no, there was outreach and no one is opposing this. It seems like the neighborhood's on board. And so that's kind of my position at this point. So
Great. Thank you. Mr. Kentwine, you have some more comments, obviously.
Go ahead. A simple question, or maybe not a simple question. Commissioner Lee, when would the phase one becomes subject to public record, is there an open DEQ matter related to the site?
If there was, yeah.
Right, if there was, but to my knowledge, there isn't. And I'm just asking you because you seem to have more knowledge amongst the group. Yeah, there's no active DEQ matter on the site.
I honestly did not search for that, so I do not know with definitively answer your question. But I would imagine that it would have come up during an environmental phase one, that there was some sort of DEQ action pending on the site, and that would have led probably to a phase two. And since the applicant didn't mention anything about a phase two, that's a good sign.
Thank you.
Commissioner Stevens.
I really support Commissioner King's deliberation, and I don't have a whole lot to add. This seems to make sense. I support the fact that this is already developed. We're not taking farmland out of production. Obviously, they're excellent neighbors, and no one's here to complain about this change. So I'm in support of it, and thank you for asking.
Great, thank you. Commissioner Satter?
The only thing I had to add, I mean, it's pretty much in line with what everybody else was saying, though. Sorry about the dog, if you can hear it. Is that, I mean, this is the zoning change, and if they're not looking at any kind of change of use or any development at this time. So given it's just a zoning change right now, with everything staying the same, it's just getting it in line with the actual use. And so there wouldn't be an environmental change impact, I wouldn't expect. If that makes sense. Sorry, the dog is being nuts.
Okay. Anything else? Okay. Anyone else want to say anything? Well,
I'd like to make a motion if that's all right, Chair.
Well, I'd like to make a comment first. I've been patiently listening to everyone else, so I figure I ought to say something regarding the matter. And I'm pretty much aligned with what I'm hearing from the rest of the commission. It's one of many examples of property that was used for what in an area that was intended for a different purpose and somehow was grandfathered in all these years. What I've never understood is why it wasn't just given the more formal exception in the first place. And we have to go through these things later in, 30, 40, 50 years later. So it seems to me like this is an easy thing to proceed with. And I will make a comment, though, regarding the loss of agricultural land. And, having been on the commission for a few years and getting a flavor of the nuances in the county, I think part of the problem with the county is we have so many properties that are really too small to be productive farm land. And we see this, we saw this earlier or last year in that application. And so the problem in my mind is the fact that we've got a lot of small parcels that have been carved up in the county over the years in the rural areas that just don't lend themselves to agricultural use anymore. And I don't know how you solve that problem. But to me, that's the bigger issue in the county. This is a kind of a no-brainer. So that's my 2 cents. So would anyone like to make a motion? Commissioner Stevens. Okay.
I move to recommend approval of files Z0437-25 and Z0438-25 to the Board of County Commissioners as recommended by staff.
Do I have a second? Commissioner Wilson, you're seconding it? Okay. So with that, Commissioner Murphy, you have your hand raised. You're muted.
Excuse me, I'm sorry. I would like to add with Martha's amendment she was asking for to limit the industrial use to minimize the traffic. Is that
Tammy,
So-
can you clarify your motion for me, please?
She
Was
said
that
as
intended?
recommended by staff, and the staff recommendation is to make that change to condition 4. So I think it's covered, and Jennifer can maybe give a head nod or shake her head. Okay.
Thank you.
I don't see- Okay. So that motion, that amendment is not necessary then? You're withdrawing it?
Yes, Tom, I'm withdrawing that. Thank you.
Okay. All right. So with that, I'm gonna do a roll call or take a vote. So I think the easiest way for me is to see if everyone uses your raise hand feature for the ayes and the nays. So for all those.
We have to have a verbal
Oh, you have to have verbal?
vote for the record.
Okay. All right. So do you want to do that for me then?
Sure, I can do it for you.
Thank you.
Commissioner Stevens,
I'm in favor.
Commissioner Murphy,
Yes.
Commissioner Lee,
Yes.
Commissioner King,
Yes.
Commissioner Founds,
Yes.
Commissioner Satter,
Yes.
Commissioner Cantonwine,
Yes.
Commissioner Wilson,
Yes.
Commissioner Peterson.
Yes.
That is unanimous.
Okay. Motion carries. So we can move on. Hold on a second. Let me get my agenda back up. Okay. So the hearing is now closed. We have a few other items. They shouldn't take too long, but if anyone wants to take a quick break before we drive into those, we can do that. Or if everyone wants to just keep charging along, we can do that.
I'm good with a 2-minute break or 3-minute break.
Okay. We'll see you back in 2 minutes. Thank you.
Martha, this was an excellent report.
Yeah, she's really good, isn't she?
Thank you. I can still hear you. Thank you.
I was hoping you could.
It must have taken a long time to do that.
Yeah.
Yes.
I admire your attention to the detail and all the nuances.
Thank you.
Yes.
I'm going to go grab some more water really quick.
Yeah, go right ahead.
Tom, what are you reading? What good book? No, Bookwise. You're on mute.
Now, well, we're being recorded, so it's probably not wise to have a conversation about books I'm reading, but I will hook up after the fact. I'll fill you in.
Thank you, Tom. My dogs appreciated that.
Yeah. Well, we've been going for almost 2 hours, so I figured people might need a quick break.
The dogs did anyhow.
Yeah. Whatever. I don't think we have everyone back yet, do we? Well, I'm gonna assume most everyone is back. Normally, I would have liked to have started the meeting, being as we have a new member to our commission, with some brief introductions for an opportunity for Tyler to tell us a little bit about his background, at the same time for him to learn a little bit about the rest of us. So if everyone's okay with that, I'd like to take some time right now before we get into the other items on the agenda to just do a quick introduction. So Tyler, can you tell us a little bit about yourself?
Yeah, sure. Briefly, I work in at Windermere Realty Trust. I'm the authorized principal broker at the Moreland office here in Sellwood. I started my real estate career about 20 years ago, about, I don't know, 4 blocks from Bryant Park. So right where apparently Darcy's hanging out on, I was over on 38th Street. I started in commercial appraisal and then I'm born and raised in the Portland metro area, went to Clackamas High School, came back to Portland, and I live in unincorporated Clackamas County, but I can see Milwaukee from my front porch. And I consider myself a Milwaukee enthusiast. I really love all of the exciting things that are happening in that downtown area over the last several years. And I'm excited to be here. I don't know what else to say.
No, great. We're happy to have you. I'll just give you a little background. I'm on my 4th term on the commission, so I've been around for a while. And prior to that, I was an engineer at the Port of Portland, but I've been retired for the last 9 years. So I'm just, and I live out in the unincorporated area as well, in the Happy Valley area. But Happy Valley is kind of across the road from me, but I'm not in the city. So anyone, Murph, would you like to go next?
Oh. Sure. Hi, how do you do, Tyler? Nice to meet you. Welcome to the commission. My name's Gerald Murphy, or Murph, and I've lived up in the Mount Hood corridor for 52 years. I have 13 years in government camp, and the rest down in just east of Brightwood, HOA, Timberline Rim, which borders both sides of the Upper Sandy River. Member of the Hoodland CPO, the Mount Hood Corridor Wildfire Partnership. Come from a blue-collar background, a lot of logging, home building, excavation, roofing, on and on, whatever it takes. Welcome.
Thank you.
And I will say that Murph's a great guy to go on a hike with if you want to go up there and learn all about what's going on. I've had several trips with him. He's a great resource. Who would like to go next? Commissioner Stevens.
Hi, Tyler. Man, you hit the ground running. Great questions tonight. It's obvious you read 625 pages. Anyway, I too have been around for quite a while. I had a few years and then took a break and a few back in it, and really thankful I did. It's really valuable to keep your finger on the pulse here. I've been on the Beaver Creek CPO board for 28 years, and the Hamlet of Beaver Creek, we're celebrating our 20th anniversary here in Beaver Creek. I'm in very unincorporated Clackamas County, lots of amongst a lot of timber land, so I get to ride my horses on it, and it's great. We have an amazing staff. You're going to learn a lot, have a lot of support, and welcome.
Thank you, Commissioner Stevens.
Commissioner Wilson, I think you wanted to say something, yeah?
Yeah, my name is Mike Wilson. I'm a retired Marine. I was in the Marine Corps for 20 years, served as Air Force. I was a pilot and flew F-4. Moved up here to Oak Grove about 30 years ago. I also worked as a director of information systems for Gunderson Marine across the river here. I've been through my fourth term with Tom on the commission. I serve on two other Clackamas County commissions, Transportation Safety Commission and the Extended Law Enforcement District Commission. I've enjoyed working on this commission, find it very interesting, and glad to have you on board.
Very nice to meet you, Commissioner Wilson.
Commissioner Lee, would you like to go next?
Sure. Welcome aboard, Tyler. My only son's name's Tyler, so you got a great name. I won't forget it. Currently, I am a civil engineer registered in Oregon, Washington, and Hawaii, and I work as the principal engineer of the land development group for Pace Engineers in Lake Oswego. Been on the board now, what, 2 years? Something like that. Been fun, been very interesting, so glad you're here.
Nice to meet you, Commissioner Lee.
Hey, Tyler.
In order, I see
I'll go next.
Okay.
Hey, Tyler, I'm Ryan. I'm a local contractor. This is my first term on here. I think I joined when Brian did. I think I'm in this a couple years and learning a lot more than I probably even knew I was going to learn doing this. Don't have a whole lot of other experience in any of the committees or anything, kind of getting into it and jumped right in on this committee for sure. So I live out in Damascus, just a contractor by trade, so nothing special there.
Well, it's nice to meet you, Commissioner Founds.
Yeah, good to meet you.
Commissioner Cantwine, you want to go next?
Hey, how's it going? Nice to meet you, Tyler. Been on the commission for a year and a half now, since early 25. Work in real estate investments, president of CWC Investment Company. We have a variety of multifamily, commercial, industrial, and then some net leased assets throughout Oregon and Washington. Pleasure to meet you.
Nice to meet you as well.
And Commissioner Satter.
Hello, I'm Jennifer. I live in Molalla, and I think I've been on the commission about the same time as Commissioner Lee. I think we started about the same time. I was on the Planning Commission in Molalla before, and I was on City Council and School Board. My background is in corporate accounting, and I've lived most of my life in Clackamas County around. My dad worked in the mill, so we did move a lot when I was a child. And I have 4 kids. They're all adults and 6 grandchildren.
Really nice to meet you.
Yeah. Well, we look forward to your participation. As Tammy mentioned, you're off to a great start. I remember my first couple of years, I hardly said a word. I was so intimidated by it all. So you jumped right in. That's great. I think you're going to be a great addition.
Thanks.
So with that, we have some minutes to approve. I presume everyone's had a chance to read the minutes.
I'd like to make a motion to approve them as written.
Okay, do I have a second? Commissioner Murphy, I see your hand raised. Are you a second? You're on mute. Okay. All right.
Fair point of information. Should I abstain from this vote because I was not on?
Yes, you can abstain. It would be, yeah, that would be acceptable.
Great.
We would understand completely. Okay. I think we can do the minutes with a aye and nay without having to roll call everyone. Correct me if I'm wrong, Darcy. Yes, I can.
Yes.
Okay.
Yes, for the minutes you can.
All right. All right. So all those in favor of the minutes as read, say aye.
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 I can count them all. Do we have anyone opposed? Let's put it that way. All right. All right. They're passed. Okay. Okay. So with oops, you're on mute, Commissioner. It looked like you were talking and you're on mute. Okay, guess not. All right, so we've had to put off the election new officers for a few months because we have reappointments of commissioners and whatnot. So I'm way overdue, way past my time. So we need to elect new officers. I did a little bit of inquiring of what interests there might be to see if we could maybe get one of the newer members to step up, but most were a little reluctant at this point. But there were two that said that they would serve again if the commissioners, chose to nominate them. So, and those were Commissioners Stevens and Commissioner Murphy. Do I have any recommendations to nominate a new chair and vice chair? Looks like
I would
Commissioner.
like to nominate Tom. I would like to nominate Tammy as the chair.
Okay. Anyone else have a?
I'll second that.
Okay, so we have two. Commissioner Stevens, do you want to say anything before we vote, or are you okay?
On my screen, she's locked up.
Oh, is she?
This is a good time to put her in this position then.
It'll be such a nice surprise for her when she gets the spot.
Oh, you didn't know. Oh, I'll call you later. So we lost her?
It looks like her screen's just frozen.
Oh, no.
I would bet she wants this. Yep.
She didn't say no to me, so I'm assuming she'll be okay if we vote her in. Do we want to give her a minute? Oh, that's too bad. Well, how long should we wait here?
Like she's still with us. I hope that didn't shock her.
I don't know.
It looks like Darcy's trying to call her.
Okay.
Okay, I have her on the phone.
Oh, yes, that'll be a problem.
Okay, so they nominated you as chair. She accepts.
Okay. All right.
He hasn't been voted yet.
Yeah, we haven't voted, but I just
Oh, they
wanted
haven't voted yet. You're not a shoo-in yet.
I just want her to know what's happening. That's all.
Okay.
Okay.
Yeah, it looks like your screen is just frozen here. Oh, that's weird. Do you want me to bump you out and then you can just rejoin? Okay. I'm gonna hang up. Okay, here we go.
All right, we'll give her a minute to come back on so she can vote. I'd take a minute, right?
Okay, she's gonna try and rejoin,
Okay.
but she accepts the nomination.
Yeah, yeah. You back? No?
You might ask for any other nominations, Tom.
Well, I just want her to be present for the vote if we can, if she can be, that's all.
We got
Still waiting.
Okay, I just sent her a new link,
Okay.
so maybe that'll work.
I think we ought to have all elections in person.
Looks like we have her back.
Ah, welcome back. Okay. So we have, it's been moved and seconded to elect Tammy, or Commissioner Stevens, I should say, as our chair for the next term. So with that, we'll take a vote. Darcy, can you do a roll call for me, please?
Commissioner Murphy,
Aye.
Commissioner Lee,
Yes.
Commissioner King,
Yes.
Commissioner Founds,
Yes.
Commissioner Satter,
Yes.
Commissioner Cantonwine,
Yes.
Commissioner Wilson,
aye.
Commissioner Peterson.
Absolutely, yes.
That is unanimous.
Okay, I probably should have packaged with the vice president, but I didn't. So we need to elect a vice president, or vice chair, I should say, as well. So does anyone have someone they would like to nominate?
I'll nominate
I'd
Murph.
like to nominate. I nominate Brian Lee.
So we have two. We have Commissioner Wilson wants to nominate Commissioner Lee. Commissioner Satter is nominating Commissioner Murphy.
I second Murphy.
Yeah, that's going.
Ooh, obviously he's not ready. Okay, so see, how do I want to do this? I guess we have two potential nominees, so we'll let the commission choose which one they want to choose. How's that? So we'll do a
Wait
roll.
a second, Commissioner Lee.
Huh?
Doesn't somebody have to second Commissioner Lee's nomination?
Oh, true. No one wants a second?
I will second Commissioner Lee's nomination.
Okay, thank you. Yes, I really would like to have two, if possible, just to. So having said that, we have two candidates. We have Commissioner Lee or Commissioner Murphy. So when we do the roll call, you can all say which one you prefer. So Darcy, please.
Commissioner Stevens,
You might make a choice.
Our first big decision.
Did she go blank again?
I think so.
Oh no.
Here's
Okay.
Murph, it says.
She's
She responded in the
Text.
chat.
okay. One vote Murph. Who's next?
Commissioner King.
This is my first meeting. I'm going to abstain because I don't know. I have not served. I've only been serving for 2 hours with folks, and so I think it's appropriate for me to abstain since I was not part of the process leading up to this.
Fair enough.
Fair enough. We'll let you off the hook.
Commissioner Founds.
I'll vote for Murph.
Commissioner Satter.
Murph.
Commissioner Cantonwine.
I'm going to abstain from this one.
Commissioner Wilson.
Lee.
Commissioner Peterson.
So I'm trying to, am I going to be a tiebreaker or am I going to make a tie?
Neither.
Neither? All right. Then I was, no offense, Murph, but I would vote for Commissioner Lee.
That's okay.
Trying to get some new blood, that's all.
We have 3 for Commissioner Murphy, 2 for Commissioner Lee.
Okay. All right. So it looks like Commissioner Murph and Commissioner Stevens will resume officer positions again. So with that, I'll turn it over to Jennifer. And we have schedule review and some other business we want to chat about too. So
Okay,
Commissioner Hughes. I mean, not Commissioner Hughes, Jennifer Hughes.
that's okay. And I haven't met Tyler yet either, but we'll schedule a little Zoom orientation. If Darcy hasn't reached out to you, she will. So it's nice to meet you. I'm Jennifer Hughes. I'm the planning director. I'm at 98% of all of these meetings, but I never do the important stuff. I bring people like Martha to do the important stuff, but I'm almost always here. So welcome, and we're very glad to have you.
Thank you.
As far as the schedule review, first, the good news, we'll be canceling the second meeting in July because you finished this item tonight. There's no need to hold it for a continuance. So July 27th is canceled. In August, Martha will be back again on August 10th, which with what I guess I will characterize as an interesting application. I mean, it is interesting. I think it's going to be somewhat complicated, and I know she's already thinking about how to try to explain this in a way that is less complicated, but it is technically a comprehensive plan amendment for a goal exception, which is not something that you see very often, and this one is a little bit different than even than goal exceptions we've had in the past. So should be interesting. I do expect there'll probably be public interest in this one. I will be relatively shocked if you don't have people to testify, which we haven't had a lot of with a lot of your recent quasi-judicial applications. There's been not a lot of controversy. I think with this one there may be. So just be prepared that we'll probably be having some testimony. Commissioner Satter, do you have a question about that?
I have a question. If there were to be something on the agenda, say this fall, and Commissioner excluded themselves from the meeting because maybe they have a conflict of interest, and probably yeah. Oh gosh, I can't remember what it is right now. But anyway, it'd be a complete conflict of interest. Would they be able to testify at the Planning Commission meeting as a citizen?
I believe the answer to that is yes. I mean, I can certainly double check that before the time comes, but I don't think you give up your right to participate as an individual if you essentially recuse yourself from an item.
Okay.
Yeah.
That person may just withhold their specific testimony for the county commissioners when it gets that far, but yeah.
Sure. Yeah. Yeah. I mean, you definitely that, and we can have the sort of ins and outs of what really qualifies as a conflict of interest.
Oh, I'll be definitely a conflict of interest.
Okay. Well, and if you feel that you would be biased.
Oh, I already feel I'm already going to have ex parte contact. Like there's going to be a town hall and everything. And I'm already, there's going to be so much ex parte contact.
Okay. So yeah, you would just not participate in the hearing. That's
so when that UGB expansion does come this fall, I will not participate. So something for the other commissioners, because when you are looking at quorum, I will not be able to participate.
Okay, that's good to know while we're planning.
Yeah, I thought scheduling was a good time to mention.
For sure. So then on August 24th, we're having another study session. We've advanced this project on clear and objective standards related to the various natural resource and natural hazards provisions of our code. A number of you will remember we had some consultants here before. We've done I believe a couple of study sessions now. The project has advanced quite a ways, and we are going to have actual draft code amendments for your, not a hearing yet, but for discussion. And we will also be doing at least one digital town hall for the public coming up this fall. So Joy Fields and the consultants will be here to talk about that with you in September. And then, in August, I misspoke, August 24th. Then we have 2 potential dates in September. We will be narrowing that down. We'll be doing a study session either on the 14th or the 28th of September on ZDO 294, which is another package of minor and time-sensitive amendments. We just finished, you'll recall, we just had one of these packages, but we're already starting up. Our first team meeting is actually Wednesday to start talking about this next package, because there are a number of things that the state has adopted that will take effect January 1st, and we need to do some work. And in at least one case, there's actual policy choices for us to make. It's not just a mandate that we have to do it, but we have some flexibility on how we do it. And we need to get that in place before January 1st. So it's a pretty tight timeline. So we will be doing a study session to talk about what all is going to be in that package. But we need to get a little further along before we decide which one of these dates is preferable. So either the 14th or the 28th of September. And then the public hearing on that will be October 12th. At this point, then we've got a hold on November 9th for public hearings. 2 public hearings, one for the city of Canby wanting to expand their urban growth boundary, and a second one for the city of Molalla wanting to expand their urban growth boundary. And then there'll be another study session in December also on the clear and objective standards project with the consultants. So there are actually kind of some weighty things coming up for the rest of the year, and quite a bit to keep you busy. I do think that both the Molalla both the UGB proposals could attract interest, but the Molalla one in particular is already gathering interest, which is what Commissioner Satter referred to. So I think you'll have some public participation really on at least a couple of these items, which it'll be good. We haven't had a lot of that for a while. So
that is a lot of documentation to read too.
Yeah, quite possibly so. Yeah.
Would we be able to tackle both of them in the same meeting? I'm just thinking that there's going to be a lot of public testimony.
Yeah.
That might be a bit much to try to do both of those at the same meeting.
I think the question becomes whether we have the time to do something different. And Martha, do you want to respond to that?
Yeah. We're hoping so, and we know that it might be a long meeting. Both the city of Molalla and the city of Canby have what seems to be a very firm deadline of the end of the year to get through their city and the county process. Mm-hmm. And November 9th was the latest date that we could schedule, and still maybe, hopefully meet that, going to the Board of County Commissioners. but also it was the earliest date we could schedule and have both cities go through their processes and get us the information. And so it is a little compressed, and we will do our best to move this along in one meeting for both.
Well, it could end up being 2 meetings if we go long anyway.
Possibly. And so also we will be, I'm going to be tacking on a little UGB 101 and the study session on the minor and time sensitive amendments also, just to sort of give you a little bit of background on the process and what happens before it comes to the county decision makers, and sort of what your role, what the county's role is in the process, to hopefully make those hearings go a little bit more efficiently.
The board has scheduled their hearings for December 1st for that. And so there is a little time. Your other regular meeting in November is Thanksgiving week, which, isn't always ideal either for the commission, but also for the public wanting to testify, a lot of people traveling and that kind of thing. We could certainly look at you can always choose to schedule a meeting a different, potentially on a different Monday or something if we need to find a way to separate them out. But we're going to need to have you finish your work so that it can be at the board on the 1st of December.
Okay. Commissioner Wilson, do you have your hand up?
Yes. Jennifer, I know we've talked about this before. I would like to see something put on the agenda as to what the Board of County Commissioners decided on our recommendations, whether they rejected, approved, or amended what we proposed for them from our meeting. That would give us a little idea of how effective we're being. And I think that would be important for us. I know it would be important for me. I don't know about the rest of the commissioners, but I want to know, how we're doing, if they don't like what we're doing, or if they think we're being very proactive with the community, or what.
Sure.
Just put it on the agenda.
Yeah.
Yeah.
I think that's a great lead-in to the other item we wanted to talk about, actually.
Mm-hmm.
So if I may, when I made a point to go to the BCC meeting, even though we had unanimously agreed with the amendments that Martha had presented, but primarily to echo our concerns, some of our concerns about one of the provisions that the state had made that didn't allow adjacent owners to appeal some of the decisions. And so I felt it was important that they hear that as well, not just read it in the minutes. So I made a point to go to the meeting. However, they were already of the same mindset. Those comments actually came out from some of the commissioners in their discussion. And so in that particular item, I think we were pretty well aligned with the commission and their feelings and our feelings on the last item, if that's what you're looking for. But I think your point's a good one, where in the future we'll try to make sure that we get a report back, just a brief report back on commission actions that we had acted on, if that's what you're getting at. Sounds like. Makes sense?
Right. So we should just really add that as a regular agenda item, I think.
Yeah.
And that way it'll jog all of our staff's memory that we need
Yeah.
to, be prepared. Because sometimes, it depends. Sometimes there's kind of, we might cancel a couple meetings and we get busy and forget, like, wait, they did have an item that we never got back to them on. But
Yeah.
yes, I think point well taken, Commissioner Wilson. And so I think everybody remembers what Tom's talking about. That was ZDO 293, which was the last package of minor and time sensitive amendments. And the board did pass those according to your recommendation unanimously. And there will be a business meeting adoption of the formal ordinance document on August 6th. And so then they will take effect 30 days after that. So we're looking at early September that will all be in place.
Yeah.
So.
However, Commissioner Cantwine had started to circulate a really well-written letter about our concerns and how to move this forward. And I want to apologize to the rest of the commissioners. I had intended to be talking to all of you these last few months in anticipation of this meeting. Unfortunately, I was dealing with my mother, who just passed away last week, so I was a little preoccupied, and so I didn't follow through prior to this discussion like I had planned. But I had an opportunity to talk to Jennifer about it, and we thought it was probably worth an opportunity for the commissioners to bring this up again. Jennifer can kind of explain how we could approach this in a way that's within the bylaws or county statutes, whatever. So I thought it was worth mentioning because it seems like there's an opportunity for us to see if we can really make some change here. And so I thought it's worth discussing it again, and maybe we could come up with a strategy as how we might want to push this issue forward going. So with that, Jennifer, do you have any comments you would like to add?
Sure. So, right, I missed I was on vacation when you had the meeting where you considered the text amendments, and I understood when I came back that this issue that staff is also concerned about, which is the kind of rollback through state legislation of community involvement in various types of land use applications, primarily in the name of housing production. That's the stated reason for the changes anyway.
Mm-hmm.
I think the concern is just the idea that the Planning Commission would send a letter, sort of on behalf of the Clackamas County Planning Commission to state legislators or state agencies is really beyond the scope of what the county sees the role of advisory boards and commissions as being. So essentially you advise the board, but the board really sets the county's message in terms of legislating or advocacy. And so there's a couple of options. As individuals, absolutely. You can testify to the state legislature, you can testify to Land Conservation and Development Commission, written, oral, whatever, as long as it's clear. And you can draw on your own experience and say, I have served on the Planning Commission and through that role. But what you shouldn't be doing is speaking on behalf of the county or on behalf of the County Planning Commission. So that's one option, and that's what Commissioner Cantwine did, was change the letter to be his own personal, and submitted it as testimony for that code amendment package. But if what you're interested in doing is having the county do something, right, to advocate for this position, then I think another option is to speak as a body to the board. So in other words, instead of drafting the letter as you started to do to DLCD, you would address it to the board. And then, certainly you can send it directly, but what normally happens is they would end up having staff potentially come and present the letter to them at one of their issue sessions and talk through it. And it would be sort of, what are you asking them to do? Then that's really the question. Are you asking the board to advocate at the state level for changes? I think that's where you were headed. And so that's open to you as an option. Of course, there's also public comment at all of their business meetings. You can sign up to give, anybody can sign up to give public comment, and there's a 3-minute per speaker. So that would be another option potentially if, one of you wanted to go and kind of share those thoughts, you'd be welcome to do that during a business meeting. But if you want to go down the letter route, I would say address it to the board, send it through me, and we'll get that in front of them in some, we'll have to reach out to the administration office and find out. But oftentimes they would talk about that at their weekly issue session. And they are going to be setting their legislative agenda. I don't know exactly, a little bit later this year for 2027. My understanding is they always, or they already have interest in something related to land use, which they really haven't had as a high priority on their legislative agenda in recent years. But they're at least talking about, it's this erosion of, it's not just the public involvement, it's also the erosion of local control.
Mm-hmm.
They're concerned about for
Yeah.
sure. So
Well, it's clearly that's where it's headed.
yeah. Yep.
I would like to give a little 2 cents on this subject too, because it happened in my neighborhood. We had a land use action in which the person bought a piece of property. They split it into 4 pieces, which went through a public land use subdivision action, which was fine. The main house was on one property. The 3 remaining pieces, they proceeded to split into 2 pieces each for a total of 6. No public notice, no land use action involved. It just happened down the road from me. Not
Yeah.
good.
It's happening all over. And I mean, obviously there are different, I want to be clear, there's people who are advocates for this, and it's not just, there are different perspectives, but I think regardless of your perspective, there is no question that there is more control from the state in urban residential development than there's ever been. And it just sort of continues to be layered. So that's a change. And then the sort of reduction of notification and appeal rights and all of that is also clearly happening. Yeah.
Very frustrating in the rural community, because here we give up a lot of amenities and services that are available in larger communities, specifically to have a quality of life, to raise families and such. There's a trade-off for that, and so a lot of people here feel like that's being taken away from us.
One other thing I wanted to mention is that if you are going to send a letter again to the board on behalf of the Planning Commission, it should be something where there's a draft and you talk about it at a meeting and vote, so that it's clearly that a majority of you want to send a letter.
I would agree.
I think we should do that.
Anyone else wanted to comment or?
Tom?
Yeah.
Commission. Recently, the Mount Hood Corridor Partnership, a member of that, who's also on the Hoodland Fire Board, crafted a letter for legislation, actually wrote the whole legislation himself, for 72 hours of backup power for cell towers in wildfire risk neighborhoods. And his angle is, what he came up with is, if he could tomorrow night can get the Hoodland Fire Department to back this, and if they, which I'm sure they will, because we're pushing on 911 numbers not being able to be called during public safety power shutoffs, he wants to solicit the special districts of Oregon, which are over 900 of them, for backing, and then present that to the legislation, which I thought was a very smart way to go. So creative thinking of who else could back this would be, this type of movement, I think, would be, time to put on the think hats and take a look. If that made sense.
Yeah. There's some chats going on as well. I see Tammy is wants to try to organize, and I had a similar thought, but realized that whenever we do any kind of a Zoom meeting that involves all of the commissioners, and it has to be publicly noticed. And so I was cautioning, I was a little concerned about us being not recognizing the fact that we also are considered a public body, and as a result, we're subject to all those kinds of things. We need to be thoughtful how we approach it. So I would I was struggling with this this last month or so as to, well, how do I want to approach this? I fully support it. I think most of the commissioners are in agreement, but I wasn't quite sure how we go about it, what we can do and still be within the county, which is why I talked to Jennifer.
Yeah, I mean, we can talk, I can clarify, but I think it's okay if, if a couple of you want to draft a letter.
Right.
And then, and then we put it in a packet and talk about it at a public meeting. What we can't have is serial discussions, or all of, 5 or 6 of you having a meeting kind of offline. It doesn't really work that way.
Yeah, and I'm well aware of that. So it sounds like what we might want to do is work on a proposal, a subcommittee, work on a proposal that we would bring to the next meeting that would then could be voted on as a recommendation to the commission. That's something we could do collectively. Beyond that, it's got to be more individual, if I understand it correctly. So for example, we can't as a board lobby our legislators individually. We'd have to do that individually. Is that a fair statement?
That's right.
Okay.
Yes, correct.
Okay. And that's kind of what I was wrestling with. Well, how do we do this in a way where we have some influence as opposed to just send a letter and it goes to the commission. That's it. That's the last, we see of anything. So, how do we, what I was wondering is how do we start kind of a grassroots effort to kind of get this issue elevated, not just from Clackamas County, but statewide. And that's the strategy I was thinking we might want to try to figure out. How could we go about creating a grassroots approach? Again, we just have to be a few of us maybe coming up with an idea as how we approach this. But we couldn't, I don't think we can do that collectively.
Chair, I got a question. So I'm playing a little catch up, obviously.
Yeah.
I haven't seen any of the letters we're talking about. Has this been discussed publicly in this forum previously this year that I could go back and watch something to kind of get up to speed of where everybody's headspace is at on this noticing issue? Like, how do I get caught up on this? It sounds like there's some momentum behind it, and I just want to jump on board.
You talked about it at your April hearing. Is that correct?
Yes.
Yeah.
I'm sure there's availability to view that, right? You
I think it was in May.
May 11th.
Oh, sorry,
May
May.
11th.
Yeah.
May 11th. So the
Yeah.
May 11th, the recording should be, I'm assuming, online unless there was some sort of issue. It should be posted on the Planning Commission webpage, and if not, Darcy probably has it.
Mm-hmm.
Should. So that would be the way to get caught up on what the prior discussion was. And then, that's kind of where then there was this effort to draft a letter, which is when I intervened and rained on everybody's parade and said, wait, slow down. We have to do this way. So that's where we're at now.
Yeah.
Commissioner King, I just sent you to the link to the recording.
Thank you very much for that. I'll take a look.
Yeah.
Okay. Well, sounds like Tammy's, from what I'm seeing, is kind of looking to run with this for next meeting wise. I suspect there'll be some offline phone conversations individually with some of us who are willing to try to figure out what we can do to get this elevated at state level. So
Yeah, and Tammy, if you want to convene, whatever, 3 of you or something like that, to just have a discussion over Zoom, certainly Darcy or I can set that up. And if you want me to be there, that's fine.
Jennifer has her hand up.
Oh, my comment was going to be that if people want to, work on more grassroots, contacting people in your city council and your local planning commissions and your communities would be good, because they are likely having the same frustrations that we are having, probably even more, because it affects their land use decisions more as they are approving more site use development, things like that, a lot more than we do at the county level.
Yeah, there's a lot of concern among cities and counties in terms of for a number of reasons about what's been happening.
I was going to say, there is an election coming up, so there is an opportunity to make it an issue with all the folks running at the state level. So anyway, enough said. All right. Any other thoughts on this whole issue? Sounds like this will be some more offline conversations, and it might come back to to the full commission at our next meeting. I don't know. We'll see. It's kind of in Tammy's shoes. Obviously, I want to be involved in any way I can help as well. So, all right. Is there anything else anyone wants to share for the good of the order, or are we done for the night?
How about a motion to adjourn?
Do we need a motion to adjourn? I don't know.
Not necessarily. Everybody
No.
can just agree with the sentiment.
Yeah, I think we've gone long enough for one night, so it sounds like we've got some long ones coming ahead of us. So let's we'll call it a night. So I'm going to adjourn the meeting. Thanks everyone for all your input, and look forward to seeing you all in a few weeks.
Thank you. See you in a couple weeks.
Thank you.
Bye.
Good night.